proceeding. So that is a little bit of a summary of that. So in this next slide, I want to shift gears. The first part of my presentation was analyzing what the common law definition of fraud was, the bill that was enacted into the law by the Senate and Assembly, but wasn't signed or was signed with chapter amendments, and going over a discussion of the changes that the governor made. The next thing I want to do is, I think what really applies here is to take a look at the amendments to the overcharge section as a result of the HSTPA, court decisions, and I think it ties in here. So that's what I'm going to focus on. What DHCR did is they created a new section 2526.7. They bifurcated overcharge complaints. Complaints that were filed prior to June 14th, 2019 are being processed under what had been existing regulations, which is section 2526.1. But they've created this new section that specifically addresses overcharge complaints that were filed after June 14th of 2019. Now, in my opinion, I understand why DHCR is bifurcating for processing complaints filed before June 14th, complaints filed after June 14th. Certainly makes sense processing-wise. I think that I would point out to all the practitioners and everyone else, when you look at the Regina decision, the wording of the Court of Appeals in the majority decision is, it's not the date that it was, the court focused on when the claim arose. So for the practitioners, I think you really have to look at when did this overcharge claim arise? Was it before June 14th of 2019? And I would argue that the prior 2520.1 should apply. Or is it a complaint where the overcharge claim arose after the HSTPA was amended, where you would use the new section 2526.7. So in order to analyze this, I think that the first thing you have to look at is an addition that was made to the definition section in the Rent Stabilization Code found at 2520.6, which addresses overcharge complaints that were filed. So they established the base date for a post-HSTPA complaint is June 14th, 2015, which complies with the Regina decision. It says if a registration is reliable, you don't have to look beyond June 14, 2015. And they identified, I put into the materials, limited exceptions. I'm going to address those. There's actually 8, so I don't know how limited it is, exceptions. But I think it's more important to focus on what is a reliable registration. And DHCR was kind enough to adopt a definition for a reliable rent registration. And by the way, the changes of the Rent Stabilization Code are in the materials that RSA and NYCLA provided. And they start on page, I believe it was 96. So when you look at this, what is a reliable registration? It says a registration is reliable if prior to filing and after 2015, the rent history contains no unexplained increases. What is not defined is what is no unexplained increases. So that means that to determine if there's ever been no unexplained increases, they're going to be looking at rental events prior to June 14th, 2015. And this is where registration, which was something that's been in effect since 1984. So for example, if you made improvements, you were supposed to reflect it on there. I would argue that if the rent registrations indicate that there were improvements, then it's an explained increase. I guess another practical pointer is you don't always see that. You have to request the right report from DHCR to see whether or not that is available. Now, a moment ago, I mentioned that there were the limited exceptions, and they're listed here. This, as I stated in the materials, opens up the door for DHCR to examine records and to look at the legal rents prior to June 14th, 2015. So some of these examples are not new. They're going to look at this and whether legality of the rent charge or registered is reliable in light of all available evidence. Again, not quite sure what that means. I foresee a lot of litigation. Obviously, regulatory status. So if you're alleging that the department had been deregulated, they're going to look at that. Prior orders, and it's interesting, it says that remain in effect within 6 years. I've been kind of wrestling with this and trying to figure out how this complies with the Calogero decision by the Cintron v. Calogero, where it says that DHCR is required to look at all of its orders. And I would argue it's not just orders negatively impacting the rent. I would also say they have to recognize orders that also positively impact the rent, at least positively for owners, like an MCI order. They'll determine whether the overcharge was willful, preferential rents. I don't want to read through all of these, but these are the base state exceptions that are identified in the new bifurcated code section that addresses overcharges filed after June 14th of 2015. So, as I stated before, DHCR has stated that they are going to look to see if a registration is unreliable, which means that they're going to look at, it says any registration, this is what they've identified, any registration or other records filed with DHCR or any other agency. So I guess if you have a regulatory agreement and the rents were recalculated, they will certainly look at that, although I guess it'll be on an owner or an agent to supply that information. I'm not sure if they would have all of that. Regulatory agreements are recorded, but I'm not sure what the processing units will be doing. I would certainly advise you to submit that. Orders that have been issued by an agency, city, state, or federal, records maintained by an owner or a tenant. This one obviously is something not necessarily in DHCR's files or their ability. This would be something that has to be submitted. And then obviously public records, as I said before, like a regulatory agreement or perhaps even Department of Building records or anything else. Late registrations. I think that this is important. It says that when an overcharge complaint is filed, if the only reason that there is an overcharge is the fact that there was a missing registration, and we all know there's no registration filed, the owner was not entitled to an increase and the rent is frozen at the last registered rent. It says that the late registration can be filed and there would be no finding of overcharge. But remember, I've underlined it, this is only if the registration is filed or the missing registration is filed or possibly amended prior to the issuance of an order. Proceedings commenced by DHCR. In the new bifurcated section, there is this 2526.7 that said that DHCR, and when I say DHCR, it could be the Office of Rent Administration, it could be the Tenant Protection Unit, where they commence a proceeding. It could be the enforcement unit. So there's various offices within DHCR that might commence a proceeding. And what it basically says is that if the agency commences a proceeding, they're going to give notice to the affected tenant and give them an opportunity to appear. And in the event that the tenant in possession vacates while this proceeding is still pending, new tenants will be given an opportunity to participate as well. Damages. I think that this is always something that is of importance. So what this says is that when an owner establishes that by a preponderance of the evidence that the overcharge was not willful, then it's whatever the overcharge was plus interest. I have to tell you that to make an argument that the preponderance of the evidence establishes that the overcharge was not willful becomes harder and harder. They've taken away safe harbor, which I'll probably talk about in a second. But this is what's important for all the practitioners. You must provide DHCR with evidence that the overcharge was not willful, that it was a result of a mistake, misunderstanding, hyper-technical calculation error, those type of things in order to avoid treble damages. Interest. Interest accrues from the date of the first overcharge, especially if there is no treble damages. Overcharge treble damages are limited to 6 years. The agency says that they will not apply treble damages prior to June 15, 2017, which is, I guess, 2 years before the Regina decision, and that there would obviously be no recovery of any overcharges prior to June 15, 2015, but they will certainly look back to determine what the legal rent is, but there'll be no award of an overcharge prior to that. So as I mentioned earlier, the pre-HSTPA code permits an owner who has collected an overcharge, whether it was without really looking at intent or anything else. If a complaint is filed and the evidence and the owner made a refund with interest, that permitted that owner to avoid treble damages and sometimes an overcharge. That safe harbor provision, as it's referred to, has been eliminated. It doesn't exist anymore. I think another item that I wanted to point out as interesting was, this comes from the HSTPA. There's now a new section that says that DHCR can impose reasonable costs and attorney fees in an administrative proceeding. However, if they award treble damages, it would just be treble damages, no interest. And with that, I did have some things that I wanted to mention about the other code changes, but perhaps for NICLA or RSA, that might be a topic for a future seminar. I will wrap it up here so that we can move on to question and answers. Thank you, everyone.
Thank you, David. So Kelly, you want to start?
Yeah,